Hello, everyone. A good afternoon to you, or a good morning, or a good evening from wherever you're joining us. Thank you for sparing time to join us today on this tax law webinar series on the first of its kind around the relevance of a tax ombudsman in the different countries in the East Africa region. My name is Kafko John Bo. I'm going to be your moderator for today. I work with country and company advocates, but I also work with Youth for Tax Justice Network. It's a Pan-African organization. Now, today, we are going to discuss the relevance of a tax ombudsman, and we are going to explore why it is necessary to have one in the specific countries in the East Africa region, but also as a regional body, as the East Africa community, whether we really need to have one. We are going to hear country experiences from the different panelists we have. And this tax law webinar series is intended to focus on highlighting the current operating environment of tax bodies within the region and discussing the relevance of a tax ombudsman. Thank you very much for joining us. With me today, I have a powerful panel to discuss this topic. And I'm just going to introduce them briefly, and then we shall get into the discussion. After the discussion, we shall have an opportunity for a question and answer, an interaction session where you, the audience, can share your thoughts or give any comments or questions to whatever has been presented. And also, you could also share your experiences. I understand that you could have had some practice around the ombudsman. You've probably had some challenges with tax or revenue authorities and all that stuff. Feel free to share. We also have a chat. You can always share your thoughts there if you feel it's not, you cannot be able to talk. But also for our online audience, we do not have all the time to have you introduce yourselves. So please just introduce yourself in the chat. You can mention your name, the firm you're working with, or the organization you're working with, and and share any other thoughts. Now, just to get back to my panel, I'll start with Mr. Solomon Rukundo. Mr. Solomon Rukundo is going to give us a presentation today about a tax ombudsman. He has written a paper, a working paper with ICTD, and it is more focused to Uganda, though it has a perspective of different jurisdictions around a tax ombudsman. He makes a case about why Uganda should have a tax ombudsman. So he's going to make a presentation of the paper, and it will set the tone for our conversation. Mr. Solomon is a manager taxation at Grant Thornton, Uganda. He has also worked with the URA, and he has lots of experience working with the Ministry of Finance, Uganda. Yeah, then just to move on to Dr. Pai. Dr. Pai is a legal scholar. He has lots of experience in arbitration. He holds a PhD. He's also a vice president currently of the East Africa Law Society, and his CV is so big. But just allow me to pause it around there. Probably he'll give us, he'll share more about himself when he comes in to speak. And then we also have, he's from Rwanda, mind you. Solomon is from Uganda. Dr. Pai is from Rwanda. Dr. Pai Habimana. Then we have George Kashindi. He's from Kenya. He's an advocate of the High Court of Kenya with over 18 years of experience. He holds an LLM in financial services and is a partner at Munyao and Muthamo and Kashindi Advocates. He has also had experience working with the Kenya Revenue Authority and working around, he has been a tax practitioner for quite some time. You're very much welcome, George. George is also from Kenya. George is from Kenya, sorry about that. Then lastly on the panel, we have...
Thank you very much.
Thank you, George. Lastly, we have Dorothy Ndazi. She's from Tanzania. Dorothy is a practicing advocate as well. and a senior associate at Hilton Law Group, heading the telecommunications and employment law department. Dorothy is, I can say, I don't know whether it's fortunately or unfortunately the only lady on the panel, but she comes from Tanzania, the only country, I think, in the East Africa region, which has legislation about the tax ombudsman. So we are going to, we are looking forward so much to hear from you, Dorothy, about how the tax ombudsman is working and any opportunities and, share experiences as well. Yeah, so in a brief, I'm very sorry I haven't, the panelists, as I told you, they are very powerful. They have very huge CVs. I couldn't go through whatever is on their CVs, but please don't feel offended, my dear panelists. I hope you don't take it in bad faith, but you can always talk about some of the things that you do when you come in to speak. At this juncture, ladies and gentlemen, allow me to invite our presenter, Mr. Solomon Rukundo, to take us through his paper. You're welcome, Solomon.
Thank you very much. I'm sharing my screen. I hope everyone can see that. Yeah.
Yes, we can see that.
Yeah, so I have a paper published by the International Center for Tax and Development, making the case for a tax ombudsman in Uganda. And that's what I'll be taking you through, essentially. The case for the tax ombudsman is a relatively simple one to make, in my opinion. The challenge arises from the need to balance the powers between the revenue authorities and the rights accorded to the different taxpayers. And these take different forms. You have the right to privacy, the right to fair treatment. So in trying to find that kind of balance, then the best way to do it is to have an intervening force that comes in to create a balance between the excessive powers, the coercive powers given of necessity given to the revenue authority. I usually like to say, and my former colleagues, I used to work at the revenue authority for about 7 years, may take it, though it should take it in good faith, but I like to say that the revenue authorities around the world function on the same premises as terrorist organizations. They function on the same basis. That is, hit a small group of people very hard and scare the rest into compliance. And when that approach, and it's of necessity, it's understood. It is understood why it is done that way. But when that approach is not checked in any way, then you end up reflecting the terrorist organization a little more than is actually intended. Yeah, so in the concept of an ombudsman developed in the 19th century, this was as a result of growth in government bureaucracies. Especially in the 19th century, government took the approach of service delivery towards people, and so huge bureaucracies began to develop. And in Sweden, the first modern ombudsman that we know was established in the 19th century, around 1809. Now in Uganda, we have the Office of the Inspector General of Government. That's probably the best known ombudsman office we have in Uganda. It was established in 1986 by statute, that is by decree, the government that was in force then, and then became a constitutional organization with coming in force of the 1995 Constitution. So the IGG, or the Inspector General of Government, deals with government as a whole, the functioning of government as a whole, without any specific direction towards the tax authority. But what we're looking at is a tax ombudsman specifically, and making a case for why there should be an office dealing specifically with tax issues. So the tax ombudsman can be in the form of the way the IGG is, that the IGG could have a special office that deals with tax matters, or it can be established as a separate office by statute or by any other special administrative arrangement. An example of an ombudsman that's part of the general ombudsman but has a specific office for tax was Australia for a long time. Actually, up until around 2016, the Australian ombudsman had been in existence since 2023, but it's only in 2016 that one clearly established. The United Nations, the OECD, the TADAT, IMF, IBFD, maybe some of these acronyms, if you're not familiar with them, TADAT is the the diagnostic tool, administrative diagnostic tool. We have the IMF, IBFD, the International Bureau of Fiscal Documentation. The CIAT is the American equivalent of the ETAF, Africa Tax Administrators Forum. This one is the Inter-American Tax Administrators Forum of sorts. Then you say they've all put up recommendations for the establishment of a tax ombudsman. So it's established that this is the best practice internationally. Then Uganda itself, its domestic revenue mobilization strategy, that's the domestic revenue mobilization strategy is the medium-term revenue mobilization strategy. It actually recommends the creation of the Office of Ombudsman. Even the Uganda Revenue Authority corporate plan actually requires that the Ombudsman should have been established within the current financial year in which we are. However, that has actually not been done. So the justification for the establishment of the Ombudsman is the administrative shortcomings of the Revenue Authority. And these are well known and very likely commonplace among all jurisdictions. Someone once told me that the mother of all revenue authorities is the same, because they behave almost exactly the same way. We have the challenges of delays in service delivery. So there are delays in objections, in granting exemptions, in refunds, in audits, in issuing private rulings, in issuing guidances. There's the TADAT, the Tax Administrators Diagnostic Tool, 2019 report on Uganda and URA established that only 6% of refunds are given within the 30-day required period. The rest all that is 94%, take much longer than that. And there is evidence of some taking as long as 2 years, even though the service level agreement that the Uganda Revenue Authority communicates is actually 30 days as per their client service charter. But we have refunds that take up to 2 years and longer. There's one case where the Revenue Authority was castigated by the Tax Appeals Tribunal for a delayed refund that lasted more than 2 years. And even though they had an explanation, and there is always an explanation, the one thing that a bureaucrat cannot lack is an explanation for a lengthy process. They say a bureaucrat will always find a reason for one more form in a process. They can always find a reason for one more step in a process. There's always a justification, but that's not the issue. The question is, how can it delay by 2 years when your service level agreement says you're going to deliver within 30 days? So audits also take long. You have audits that begin and never end, that are resumed after a number of years. There is the disregard of statutes of limitations. And take note that the issues I'm raising here some of them can be legal, and one could argue they could go to the Tax Appeals Tribunal or be handled in any other legal manner. But some of them are hard to raise in that way. So, for example, when your refund has delayed, you may not have a tax decision which you can then take to appeal. You don't have a decision made. It's just a lengthy process. So there is a disregard of statute of limitations. There are limitations on how far back the Revenue Authority can go, but for a variety of reasons, the Revenue Authority may disregard that and go beyond the period required. In Uganda, it's 3 years for going back in assessments and 5 years for keeping documents. And yet the Revenue Authority, there are endless publicly available cases where they've gone back more than a decade and require the taxpayer to have the documentation kept. And the result is that the practice in many firms is to advise taxpayers never to get rid of their documents, even though the law says they need to keep them only for 5 years. Then an interesting one is contradicting its own guidance, be it in private rulings or practice notes. Private rulings are communications directly to the taxpayer, which are binding by law on the Revenue Authority. And practice notes are general communications to the public, guiding on an interpretation of the law. And yet there are many cases. I found more than 10 court cases where the revenue authority had given specific guidance or a private ruling or even its own practice note and was then acting contrary to it. And it's understood that the revenue authority should be allowed to change its mind. But then the problem is, in all those cases, they were attempting to go back and assess the taxpayer for having to penalize the taxpayer basically for having followed guidance given by the revenue authority. Blatant disregard of the law, where the law is very clear on a particular subject. It need not even be litigated because the law is just stating it. A taxpayer has a specific right, but the right is being denied. So, for example, in Uganda, we have the challenge of taxpayers' rights to election. When an objection goes beyond 90 days, then the taxpayer has a right to assume that this objection has been accepted. But when a taxpayer applies for that, it's done online. The revenue authority has a choice of either accepting or rejecting, and almost by default will always reject, despite the fact that the law is clear that this is a taxpayer's right. Charging even higher tax rates. This was done administratively, or in effect administratively, by not changing the rates applicable to presumptive taxpayers. The law changed the rates applicable, but the revenue authority only changed the rates applicable on the system after about 11 months. This was in 2021. So disregard of court decisions. There's a whole litany of court decisions we can go through that are not being honored by the revenue authority, as some even blatantly so. I've had situations where I've quoted a court case in response to giving an interpretation, and a clear interpretation, even at the level of Court of Appeal. And the revenue authority can disregard that and just do it with impunity. And even disregard of court orders, direct orders to the revenue authority have been disregarded. There are endless cases where that has been proven. And the creation of its own law. The revenue authority creates its own law by way of practice notes, sometimes even without a practice note. It will just begin its own practice. There have been many decisions by the Tax Appeals Tribunal pointing out that a particular practice note is an overextension of the powers of the Commissioner General to interpret the law. Is that the Commissioner General has gone beyond interpreting the law and is now making the law himself or herself. The irrational exercise of discretion, maybe the domestic VAT example that needs to be highlighted. It's the most glaring example of creation of its own law, where the revenue authority basically, on top of the normal VAT, came up with its own VAT. The normal VAT, the VAT rate in Uganda is 18%, but the revenue authority created its own rate at 15% applicable on top of the normal VAT in certain circumstances at importation. And this was from 2002 until 2020 that this was enforced by being done by the revenue authority administratively. And again, there's always a justification. It's not that they are acting like mad people, as they may sometimes report. There's always there can be a justification, an arguable point, but that is not the issue. The issue is whether this is legal or not, and it was found to be totally illegal and unconstitutional by a Court of Appeal decision. Irrational exercise of discretion. There's discriminatory treatment where today the revenue authority grants a particular facility to a taxpayer, and then the next day treats a different taxpayer differently on the very same, who is in the same circumstances as the earlier taxpayer. Then inadequate internal complaints handling mechanism. So the knee-jerk reaction to all this by the revenue authority would be to say, oh, we have an internal complaints handling mechanism. But if you examined it, you'd find it doesn't even make any sense. What I mean is, if you go on social media and put in a complaint, you might be heard. Depending on the circumstances, some kind of follow-up may take place, and depending on the nature of complaint. But then that's restricted basically to those who use social media to communicate. Alternatively, if the person who is handling your matter, the officer handling it is not handling it in the proper way, you can complain to that officer and hope that they will change their mind and tell them, please change what you're doing. Or you can complain to their supervisor or their manager. But all that, again, is clearly going to be a problem why it is going to be a problem, the internal mechanism can never be adequate, is because there are situations where the revenue authority itself is thriving on its own inefficiencies. What I mean is, if you are the manager in charge of granting exemptions, you will not make your name great. You will not make your name, you will not make a name for yourself leading to an increased chance of promotion by granting exemptions expeditiously. The faster the exemptions are being granted, the more questions you may arise. You have the internal audit function to consider. They are going to query, why are you giving these exemptions so quickly? There are just some inbuilt, inherent aspects that cannot be changed internally, in my opinion. And I say this as having worked there in the one in Uganda for at least 7 years. The inadequacy of existing institutions. So there are oversight institutions in Uganda, and I'm sure these are mirrored in the other East African jurisdictions. We have the tax policy department in the Ministry of Finance, and this is just wholly inadequate. The tax policy department in Uganda has 27 staff currently, and of these, only 21 are technical. The rest are secretarial, clerical, and the like. So you basically have 21 staff as the ones going to handle each and every case, complaint, and follow up on it, which is impossible. And when that is not even their key mandate, and then they may not even want to step in the way of the revenue authority collecting revenue. I mean, the Ministry of Finance is the one putting pressure on them, giving them targets, and perhaps leading to the authority behaving in the way in which it may behave. And so they may not be trusted to deliver. And again, the staff is inadequate. The Office of the Auditor General focuses on, in writing my paper, I reviewed the reports of the Auditor General going back to 2014, up to date. And the Auditor General focuses squarely on issues of why is sufficient revenue not being mobilized? Why is the Revenue Authority not collecting enough revenue? That is what the key focus is on. And so you may not trust the Auditor General to pay that much attention to delays in refunds, in money going out of the Revenue Authority as opposed to coming in, or in granting exemptions to which one might be entitled, or to any other service delivery issue that may arise. Then the Inspectorate General of Government, that's the IGG. Currently, over the last 2-3 weeks, there have been a number of headlines, and by headlines I mean actual front page news in the newspapers, where the IGG, the Internal Inspectorate General of Government, is looking into the Uganda Revenue Authority, and is supposed to issue a report soon. But it's all about corruption. The focus is on questions of corruption, of integrity. But sometimes these service delivery issues are not about integrity. They have nothing to do with corruption. They are purely about service delivery, simply being slow. As I've said, the manager in charge of exemptions simply or in charge of refunds, acting under the inherent systemic incentives built in the institution. They are just not going to expedite this because there's no reason to do so. And there's not because they are even seeking a bribe. So the IGG would not be able to follow up on such cases where there is no corruption issue, because their focus is primarily on corruption. Then we have Parliament of Uganda. So the Parliament of Uganda, the Budget and Finance Committees, these are two different committees that have oversight over the Uganda Revenue Authority. But their limitation will come in the fact that they sit there. I mean, they sit from time to time. They cannot look into each and every single case. At best, they may look into big high-level cases, or it might be the systemic issues that are complained about over a long period of time. But that lone, simple taxpayer who is struggling with dealing with the Revenue Authority and is being bounced from office to office will not be able to get a service from the Parliament of Uganda, from a parliamentary committee. And moreover, you have to consider that the members of parliament have incentive not to look too deeply or too keenly into what the Revenue Authority is doing. That's because they are also businessmen and women who sit on these committees, and you have to be cautious when you're dealing with the person who controls the tax system and could easily turn it against you and start looking into you deeply. There are examples of this where when the lists of tax defaulters were published. It was published by the Revenue Authority twice. That has been published, that it contained members of parliament who were tax defaulters as well. And some of them even sitting on the budget and finance committees. So one has to question whether they would really look so deeply into this. Then we have the Tax Appeals Tribunal and the courts, the court system. When talking about the tax ombudsman, that's the pushback I frequently get, that how is this different from the Tax Appeals Tribunal or the courts? Why is it not a duplication? Because the Tax Appeals Tribunal and the courts deal with issues that are legal, the interpretation of the law, disputes as to facts. But when it is just a service issue, when you have your refund that is being delayed, when you've applied for VAT registration and someone is just sitting on that application, is not approving it, you going to the courts may not be possible. There's no decision. There's not even a tax decision that you can take to the courts to have redress. And even you have to consider the costs involved. For Uganda, before you go to the Tax Appeals Tribunal, you have to pay 30% of the tax in dispute. So that is a challenge that taxpayers would have to contend with, and you probably have to hire a lawyer or an auditor. You don't have to be a lawyer to go to the Tax Appeals Tribunal, but you would have to hire someone like me, and I may not come cheap for that taxpayer. Then the tax ombudsman, we see the role the tax ombudsman can play is complementing the oversight of these institutions without infringing on their mandate. If you look at what the tax ombudsman is supposed to do, none of these organizations are doing it as yet. So there is no infringement of mandate. It is simply complementing it. The tax ombudsman can support proportionate dispute resolution. Proportionate dispute resolution, the idea here is that you should use the mechanism that best suits the kind of dispute. So if you have an officer who is for whatever reason simply being stubborn, a revenue officer who is being stubborn or is delaying to handle your matter, it may be too trivial for you to take through the whole court process. It may cost you a lot more than what you're going to benefit from this person handling your matter expeditiously. So you should use the dispute resolution mechanism available should be proportionate to what the challenge that you're facing. The alternative dispute resolution regulations have actually come out recently. They came out at the end of March. They lay out a process for alternative dispute resolution for the Uganda Revenue Authority, and I'm sure that would be one of the responses they would probably argue as a solution to the challenges faced. But if you look at those regulations, there's nothing there that is a solution. They say you must you apply for the alternative dispute resolution within 7 days of receiving the objection decision, which is just strange. The whole process, when you go through it, is one that favors the authority so much. One may opt not to take that route if they have a choice. Then the tax ombudsman can help reduce tax-related case backlog. That has been a frequent complaint. That's actually why alternative dispute resolution was encouraged by the Tax Appeals Tribunal. As was pointed out, I used to do work with the Ministry of Finance, and I know it was the Tax Appeals Tribunal that championed the introduction of alternative dispute resolution. Unfortunately, as I'm mentioning, the regulations are skewed so much in favor of the Revenue Authority that process may not be taken too seriously now. The tax ombudsman supports equity and access to justice in tax disputes. What is meant here is that the big players, the powerful taxpayers have means of accessing justice in other ways. For example, we have, this is known publicly, there's a presidential investors roundtable where the powerful investors can go and complain about the different infringements by agencies, by government agencies, and get solution, get a quick solution through that mechanism. But the ordinary small taxpayer has no such access, and so they tend to suffer. So the tax ombudsman has a role to play in domestic revenue mobilization. By fulfilling his or her role, the ombudsman will build tax morale in the country, because the willingness to pay will increase when there is efficient delivery of services. There will be tax certainty because there are the endless changing of position by the Revenue Authority, and and the risk that they will go backwards and assess you for having followed their guidance will not exist anymore. And it will reduce corruption in tax administration because you now have an alternative to having to pay to bribe an officer. You have an alternative means of accessing justice. So we can look at the ombudsman in some select jurisdictions. In the UK, the tax ombudsman is called the revenue adjudicator and was set up in 1993. It is set up administratively. There is no law that creates this office. It is just an administrative creation that has exists by way of service level agreements with the His Majesty's Revenue and Customs. And it is limited to mistakes, unreasonable delays, poor or misleading advice given by the Revenue Authority, poor processes, whether or not a policy has been followed, a stated policy by the Revenue Authority has been followed, and the inappropriate staff behavior or inappropriate use of discretion. And the recommendations of the Revenue Adjudicator are not binding. The Revenue Adjudicator uses staff from HMRC to do their work. They just appoint the person at the top, then the rest of the staff are borrowed from the HMRC. In the US, it's the taxpayer advocate. It's the tax ombudsman office, an office akin to an ombudsman was set up administratively in 1979, but was put in statute in 1988. And they issue taxpayer assistance orders, which are binding. So these are orders which can stop the Revenue Authority from engaging in a particular activity. Then they were previously appointed by the Commissioner of the Internal Revenue Service until 1998, when now they are appointed by the Secretary to the Treasury, the equivalent of the Minister of Finance in the United States. They can now issue the Taxpayer Advocate Directive. A Taxpayer Advocate Directive goes beyond the Taxpayer Assistance Order and can deal with the systemic issue. So instead of dealing with just a particular taxpayer's challenge, the Taxpayer Advocate Directive can deal with an issue and can bar the Revenue Authority from acting in a particular way. Now, to become the taxpayer advocate, one must not be an employee of the Internal Revenue Service for 2 years preceding or 5 years following their tenure. So they commit not to work for the Revenue Authority. And this is to do with incentives being created, depending on how they will work, if they know that they may get a job with the Revenue Authority. Then in South Africa, the CATS Commission recommended the creation of the Independent Tax Ombudsman. And in 2002, the South African Ministry of Finance created the South Africa Revenue Services Monitoring Office, the SSMO. This was found to be inadequate. And in 2011, the Tax Administration Act created the Tax Ombud. That's the Tax Ombudsman equivalent in South Africa, called the Tax Ombud. And it is appointed by the Minister of Finance for a term of 3 years and must have a good background in customer service as well as in tax law. And they only handle procedural matters. They cannot handle any interpretation of law matters or any matters subject to appeal. And again, their recommendations are not binding. The South African Tax Ombud the office is manned by staff of the South African Revenue Service as well, on loan to them. So the proposed office in Uganda would be a juristic personality established by statute. So there would have to be a clear statute establishing it. The reason is because if we try to go by way of an administrative action, the office won't be strong enough because there will be pressure from the Revenue Authority and all kinds of other places. So we need to have a juristic personality created by statute. Ideally, it should be the Minister of Finance to appoint the tax ombudsman. The ombudsman should be someone intimately familiar with tax administration. Ordinarily, one would think of someone who has worked with the Revenue Authority, but we would recommend that this be someone who has not worked in the Revenue Authority for at least 5 years and should undertake not to work there for another 5 years after leaving office. The ombudsman must have a fixed long term of office, so about 5 years, so that they can have some security of tenure and also take time to learn the way the office should be run. There should be some linkage to the legislature through a statutory requirement to submit periodic reports to the legislature. This can be to the committees, the budget committee or the finance committee. And the tax ombudsman must be perceived to be independent and impartial. The impartiality is very important, and so any actions that infringe on that impartiality should be avoided. Ideally, for purposes of impartiality, they should have their own staff, but for practical purposes, given the challenges of budgeting, it might be appropriate for them to have revenue authority staff seconded to them. Then they should be able to handle complaints relating to mistakes, omissions, and oversights, undue delays, poor or misleading information, unfair treatment, and staff behavior. These recommended issues to be handled by the Ombudsman come from the Domestic Revenue Mobilization Strategy of Uganda. That's a document issued by the Ministry of Finance, laying out the Domestic Revenue Mobilization Strategy to be adopted over the course of the next few years. It's from 2019 to 2024. There should be a requirement of exhaustion of URA's remedies before the tax ombudsman can be activated. So one should not just go to the ombudsman directly. They should first try and deal with the issue from URA, and when they have failed, then they can go to the ombudsman. And time to seek redress through the tax appeals tribunal or any other means should remain pending. So there should be a freeze on time. There are time limitations in which one can seek redress through the courts. So there should be a freeze on time when one is seeking redress through the ombudsman. And the ombudsman should have unfettered access to any information and to any relevant officer. That is, they should be able to go and talk to a particular officer or get any information from that officer without going through any complex process. In my research, I found that in Australia, there was found to be that barrier, that the ombudsman was facing a challenge that they had to first go through these significant processes before an officer was willing to talk to them. So it should be clear that they can address the officer without going through any complex processes of getting authorization for them to speak. Then the recommendations made should be non-binding, and this is to avoid complexity and also the complexity being the risk that people would start relying on the ombudsman and seeking to use the power of the ombudsman to bar revenue mobilization. So they should be non-binding, but the main power should remain in publicity. So publicity can be the willingness to publicize a specific case if it's not being handled properly, if the revenue authority remains resistant to the recommendation, the specific matter could be publicized at the cost of the ombudsman taking on the matter and publicizing it, or it can be reported in the reports, periodic reports given to the Ministry of Finance and to Parliament. And with that, I thank you for listening to me. That was my presentation.
Thank you very much, Solomon, for that thorough presentation. I like the fact that you take us through from the justification why we should have it. You take us through the challenges that the tax system in Uganda has, and then you give the solution, the perfect solution, which is ideally should be the silver bullet to solve these challenges. I like it, but I would love to get into our panel discussion, just to pick it up from where Solomon stopped. Your paper was focused on mainly recommending a tax ombudsman for Uganda, but we already have an ombudsman in Tanzania, and we have legislation to that effect. And I think some of the recommendations you talk about in your paper, Solomon, are reflected in the legislation. So I just want to go on to Dorothy. First of all, give us an experience on how it's working. I think the legislation was introduced in, I think it was 2021, about 2021 or 2020?
2022.
Oh, 2022. Yes, so sorry about that. Yes, thank you so much. So Dorothy, could you just give us a snapshot on how it's working? I know it may be too early to judge on whether it is successful or not, but could you just give us an experience? I mean, Solomon said a lot about some of the challenges that we are facing in Uganda, and he hopes that a tax ombudsman would solve some of these challenges, especially the administrative challenges. I don't know. I want to hear from you, Dorothy, whether for the time the ombudsman has existed in Tanzania, some of these challenges are being solved. Are there any other new challenges coming up? How is the tax ombudsman coping with working with other different agencies? And how are they cooperating with the revenue authorities? What opportunities are there? Just give us a general experience, Dorothy.
Okay, good afternoon, everyone. As you said, John, this ombudsman in Tanzania is also a very new idea that is we're just trying to cope with. And actually, the regulations were passed last year in March, and the regulations actually they set up now the procedures and what is to be done with regard to the ombudsman and the whole tax issues, but particularly in the administrative area. So we all know that before 2019, what was there actually was just the tax revenue board, and that is for technical aspects on the tax assessment of the tax and other technical aspects. And if a person was not satisfied with the decisions, the appeal was to be made to the tax revenue appeals tribunal, and later on you could go to the Court of Appeal, which is the final decision maker in these matters. Now, this ombudsman was just introduced like effectively last year, and it's about 1 year exactly since it has started. And of course, the aim is to avoid all those issues, the bribes and the system which is not so well put that is available right now, because you could find that there are challenges in the administration, and then a taxpayer has nowhere to go to report or to work on that. So there was no forum, literally, where these things would be addressed. So this is a huge step, I can say, because at least now we know that we have a forum where if you're aggrieved or if there's anything that is not proper in the administrative aspect, you'd actually go to the ombudsman. And it's specifically, you can't go to the ombudsman outside the revenue. Here we call it the Tanzania Revenue Authority. So it has to be either the officers of the authority or the Commissioner General or the Commissioner General or the TRA in large. And the first thing is that you have first to have to go to the TRA and have evidence that you've been there, you've taken the challenge there. Either they've not responded, or you're not satisfied with the response, or the response is not out in about 30 days, which is legally required by the law. So that's when you can go to the ombudsman. And you have to have evidence, and you have to have like a proof that you have had communications before, which is quite of a challenge, because the procedure could easily dismiss people to use this forum, which is very exciting actually. And we're very glad that we're the first country to have it. And what I can say is we're still on the practical. We can't really say how effective it is, because, you know, if a system is just new, the first thing is you have to understand how it works, and then people have to know that there's this forum. So actually, you can say that most taxpayers really do not know that it exists and that there is this opportunity or avenue that they can use so that to report cases which they're not comfortable with regard to the authority. So you cannot say that people really use it as an avenue to solve the challenges so far. So more has to be done to make sure that the ombudsman is made well known to the general public. And this is one of the tasks that the ombudsman is required to do by law, to make sure that the general public is aware that it's there and of the functions that it's supposed to perform, and make sure that everyone knows what really goes on with the ombudsman. So in a nutshell, what I can say is that it's very new. We're still trying to see how it works. And most people are not aware that it exists even, because it's very new. So as much as it's a great step, and we're hoping that it will solve a lot of things, because going to the normal procedures of reporting these tax issues takes time, usually 2 years, 5 years, sometimes to 10 years in certain cases. So since this is a confidential forum, and they're supposed to make sure that the decisions are made in a short time and everything is done in time, we are so hopeful that it will be a very, very great avenue for taxpayers and for the revenue at large, because if the administrative hurdles are a lot, you can find that most taxpayers who are supposed to be paying tax, they try to avoid, or they try to look for ways so as not to adhere to what the law provides. But now, if it is clearly provided of what avenue can be done in case there is any issue, it is very, very comforting that there is a good future towards our tax collections and to the taxpayers, to the tax collectors and to the taxpayers at large. So far, the decisions that are taken to the Ombudsman, they're supposed to be made in 30 days. And after that, the Minister of Finance is actually the one who the Ombudsman reports to and gives out the recommendations. And then the Minister is the one who goes to the TRA as the authority to make sure that now they do what is deemed necessary. So you can see that the Ombudsman does not have direct effect to the authority, but rather it has to report to the Minister, and then the Minister will go through the deliberations, and then they'll have again to go to the authority now to see what can be done. So actually this is what is done, and I'm so sure with time, it's going to be a very great ADR or alternative dispute resolution method in our country, on top of what was previously existing, the TRAB and TRITE, which were used actually for the very technical matters. And there is an opportunity that we could use this Ombudsman as an ADR to the also technical aspects in certain cases, because of the time frame, as I said, like the TRITE and TRAB somehow takes a long time into reaching the conclusions or the decisions. But you can find that these in the Ombudsman, it's only 30 days the decisions are supposed to be made. So I'm hopeful, and we are hopeful that in the future this can be also taken into account so as to make sure that these tax cases are concluded and the decisions are reached in a short time, to ensure that nobody wastes time, neither the authority nor the taxpayers. So that's in short what I can say about this new improvements in the tax area in our country.
Thank you very much, Dorothy, for sharing that experience. I really appreciate that. I understand how the legislation has just come in, and it's too early to judge. But thanks for sharing that experience. I just now want to move on to George. I've seen here a comment in the chat from Khadija Yusuf saying that the tax ombudsman in Kenya is a toothless dog. Is actually treated as a toothless dog. Just to have you come in, George, I want you to share the experience of the tax ombudsman in Kenya. Do you agree with Khadija here in the comment, or you have a different perspective? And I also want you to share your experience. I understand you've worked with the Kenya Revenue Authority. You have that experience. I don't know that you worked there when the tax ombudsman was already in place, but I wanted you to share that experience on how the Revenue Authority interacts with AGR, alternative dispute resolution. But also, I think this also came out from Solomon's presentation that most revenue authorities act like terrorists. I don't know whether that is the case there, and whether they are really open to ADR. I mean, if the ombudsman is there, are they welcoming to them? Please, George, go ahead.
Yeah, thank you, John, for the introduction and for the kind remarks, as well as Solomon for that very informative, incisive presentation, very well written paper, which I've enjoyed to read. I'll just take you through the Kenyan position, and I'll be reflecting on personal experiences, both at KRA and in private practice, what I've observed, because I joined KRA just after my law degree, and I went into the revenue departments there for training, after which I was able to also work in the revenue departments and then legal departments, where we were providing counsel to the commissioners on a day-to-day basis as they undertook the assignments. So the tax system is, of course, in every jurisdiction very complex, and it can be sometimes described in the words that have been used, because for tax, the government is actually trying to take parts of your money using some legal means and sometimes extra legal means, and to apply that money for the development of the country. So many people would run into these problems around tax. So our constitution has provided under Article 59 for an ombudsman who is more general in nature. So under that article, we have the Commission on Administrative Justice. Of course, we have the Kenya National Human Rights Commission, as well as the National Gender Equality Commission. But this Commission on Administrative Justice is what we refer to as our Office of the Ombudsman. And it's more general in nature because it handles a lot of issues across the entire spectrum. They are not specialized in tax area. I have seen, personally, I've handled cases where they have had to deal with the complaints originating from KRA, which is the Revenue Authority. But the fact that they are general in nature then means that they are not able to provide very focused sort of help to taxpayers. And tax by itself is very complex. There are a lot of transactions, there are a lot of complaints, a lot of interactions with the revenue officers on a variety of matters. And this is one of the issues that I'll be raising that would call for creation of a special office that is empowered in law to be able to discharge this role. We have seen, for instance, the judiciary had an ombudsman. So it's possible that an ombudsman can be created within particular sectors or arms of government to play different roles. And the judiciary one addresses complaints for people that go to court. If you have a complaint against a judge or against a matter, if it's taking too long, if a file is lost and you're not getting help, then they should be able to assist you. And this is in addition, of course, to the Commission on Administrative Justice, where you can also be able to complain on certain matters that are prescribed in their legislation. Now, how does tax dispute resolution in Kenya work? I'll just highlight that disputes would, of course, start either during assessment or other revenue procedures, and they can be settled by discussing them directly with the revenue officers so that the matters are dealt with and they could be settled at that particular point. But at some point, the taxpayer may be issued with the, for example, if it is during an assessment, they could be issued with a letter of preliminary findings. They disagree with the officer, therefore the matter cannot be settled. And that matter would require then to be escalated. And it's then taken, a formal assessment would be issued, and then the matter would be subject to what we call an objection. So the taxpayer would put in an objection so that the objection can be processed internally by KRA. KRA now has a department, a tax dispute resolution department, that has somebody that you would liken to an ombudsman, an independent review office, which is an office within the legal departments of KRA, who are going to sit and review this case. And they are going to be reviewing it against the officer who raised the assessment. And they may disagree with that officer, or they may agree with that officer at that particular point, in which event the objection would then be, an objection decision would be made, and the decision would be that the objection would not be upheld. Sometimes they would vary, and some parts of the objection are upheld, and so forth. From there, we also have another internal process within KRA, which is the alternative dispute resolution, where the taxpayer can then escalate the matter and have it discussed under the ADR section. But again, this ADR section sits within KRA. The persons who are facilitating the ADR would be employees of KRA. Of course, they are distant from the case, but they are still nonetheless officers from KRA. So those officers would be in the ADR section, and they would listen to the commissioner's case. The commissioner would make presentation, the taxpayer would make presentation, and they will try to facilitate an agreement. And most of the time, it has been about how much can you be able to pay out of these assessments, what are you accepting, and so forth. Though I must say that in some cases, this ADR process has yielded good result, where the taxpayer, of course, the case has been upheld and the matter has been closed, and the revenue officers have been told not to proceed with the assessment. If you do not go to ADR and you have an objection decision, then the matter is usually escalated to the Tax Appeals Tribunal. And you would then be able to file this within the prescribed time. You have to give a notice, and then within 30 days, and then you have to file your appeal within 15 days or so. The Tax Appeals Tribunal, again, has for a long time had a problem, because it has been an internal sort of body. KRA would, the Treasury would exercise a lot of control, in the sense that they would then appoint the members of the tribunal, the chair of the tribunal. So the qualification was that you had to have worked at KRA, have been a loyal officer, you've retired, and then you'll be rewarded with a position at the tribunal. And of course, that created a lot of issues, because then if you've been rewarded, the chances are that you want also to be able to be kind to KRA. And a lot of issues around the tribunal. The staff were from KRA. They were housed at KRA premises. Their lunch and tea and allowances were paid by KRA. And so this does not provide, or did not provide, a very good mechanism for being very objective, being fair to taxpayers. At least the perception of fairness could not be achieved. But I'm happy to report that the tribunal has since moved It's now under the judiciary. The Judicial Service Commission is now responsible to be able to recruit the members, recruit the chair, and also to be able to operationalize, fund, and sort of supervise the affairs of the tribunal. After the tribunal, if you are dissatisfied, of course, then you have the option to go to the High Court. You then have the other option again to go to the Court of Appeal, and you can as well go to the Supreme Court based on the issues that are raised in the case and whether the case would be suitable for Supreme Court. Since we are in an East African Law Society forum, I need also to point out that for selected matters, you could have avenue to go to the East African Court, since we have a common East African legislation on customs and related matters touching on trade. There is great need in closing for a strictly speaking, properly legislated tax ombudsman. And I say this because from my experience from KRA, you would see that there is a lot of complaints, and those complaints would then go to Treasury. Taxpayers would complain. Treasury would then try to intervene by speaking to the commissioners, having some forums, organizing some meetings of understanding and so forth. Some complaints would make their way to other ministries. Say certain traders are affected, it would go to those ministries. Some complaints could go to professional bodies like Kenya Association of Manufacturers, come back into KRA. Some could even go to State House. And then, State House would want the issue to be resolved in a certain way or certain considerations to be made. Now, that paints a case for need for a properly functioning tax ombudsman office. And I'm aware KRA has an internal mechanism for handling complaints. Which could be around service complaints, legislative complaints, staff complaints, aspects of whistleblowing, and many other complaints that arise in day to day. But these are not addressed well. You apply to KRA for tax compliance. If the officer is happy, they can process it. If they're not very happy, they will not process it, and you could miss a job opportunity. You could miss certain aspects of business. So I think we do require in Kenya proper legislation. We need to remove this complaints handling from KRA so that we have it in an independent office separate from KRA. And I'll be making just very quick points, some of which I got from research and the paper that Solomon had presented. KRA has so much power currently. So they would freeze your account, or they could issue with an assessment. But if, for example, God forbid, they have your money, then they will not refund you. They would refuse. They would sit on the refund. So we need somebody to balance that power and to check on their excesses. That's number one. Then point number two, some issues around KRA are not appealable, or they do not make sense to appeal. These are issues where such an office should be able to be available to speak to KRA, tell KRA you are making a wrong decision here. We have looked into this. Please take remedial measures, or please make a decision on this particular case. The third issue and justification for this particular office is the bureaucracy in a place like KRA. So many people to make a decision, no one wanting to make a decision, this hand not knowing what this department is doing. And for that reason, things get stuck in that system. And therefore you require an office that has authority, an office that has ability, to look at the issue and offer a clear direction, offer some sanctions so that things move. The other issue is the complexity of the tax. matters. Currently, if we have to go through the other ombudsman, the general ombudsman, and I've seen cases that go there, they do not understand what we are talking about. They do not understand what the dispute is. They don't know what is an assessment, why an objection was led, if it's led for a few days, what does that mean, and so forth. And therefore, because tax is very, very critical, you require to have an independent, specialized office headed by somebody who has experience in tax matters, so that they can be able to deal with those issues. The other issue is building trust. And I've seen this in my practice. When there is trust, for example, an independent person looking at what KRA is saying, and also looking at what the taxpayer is saying, and they arrive at some form of decision, there is a high acceptability rate for that decision than when KRA is making these decisions themselves. Sometimes they can be very high-handed, and therefore you require this office to be able to balance that. And that, as Solomon has said, is going to increase compliance. Compliance rates are actually going to go up, because once you are fair to taxpayers, then they are able to see the need. Then we also need somebody with power to investigate. Currently, these mechanisms that are in place are not able to investigate. We require an inquisitorial system. Somebody will go and ask KRA, bring us these records. Why did you do this? Give us these particular documents that you are supposed to be having, and therefore put pressure on them. The adversarial system in court requires us, when you're going to court, to be having these materials, but we require somebody who can inquire so that they can get us, the right information, things that KRA is doing, under behind the scenes, to come to the fore. Somebody who can be able to ask those questions. Then we also require to have these processes housed outside KRA for perception of fairness, because if these processes are within the revenue itself, then there is the feeling that, these persons are tilting on the side of revenue, because they have to earn their salaries from KRA, and the people in ADR will be told, look, we have to collect money. Therefore, you have to reach settlements that bring money to us. But if these processes are fair, are removed from KRA, then you can rest assured that everything will be done well. Last but not least is, in my personal perspective, view, I think that KRA would work better if they know that somebody is looking, somebody is going to ask questions, so that these, citizen taxpayers who sometimes are sent away, their accounts are frozen, they are denied refunds and so forth, they can have some recourse, and the officers dealing would know that somebody somewhere is actually looking. John, I want to pause there so that we can move on to the next step. But thank you very much for the opportunity. I think I'll be able to cover the things as and when they come up.
Thank you very much, George. You raise very important questions and very important recommendations at the same time about an ombudsman in Kenya. And I think you agree with the fact that it is a toothless dog, the administrative one, and you recommend having one in the legislative lines. Thank you very much. In the interest of time, let me also invite Dr. Pai to share his thoughts about the ombudsman from a Rwanda perspective. Dr. Pai, I know you have lots of experience in arbitration. You've worked a lot in scholarly materials. You've published a lot of work and done a lot of research. Please share with us your thoughts about the tax ombudsman in Rwanda. I don't know how the practical aspect it is, whether you have an administrative one or you have one in a legislative shape. I don't know. You could share with us, and also at the same time, you could we could compare notes about what is happening in Rwanda vis-a-vis what is happening in Tanzania, Rwanda, Kenya, and Uganda. You're welcome, Dr. Pai.
Okay, thank you, John. My name is P, not Pi. But I understand several people,
Sorry about that. Sorry about that.
My name originates, comes from French, and in French we say P. So thank you, John. So I will start from the question you asked. So in Rwanda, we don't have a tax ombudsman per se. And so far, to the best of my knowledge, there is no registration in the pipeline seeking to institute the tax ombudsman office. Probably we will learn from Tanzania, where they have such registration, and those other initiatives from Uganda and Kenya. Maybe in the future we learn from your experience and have one. So as far as the Rwandan perspectives are concerned regarding the office of tax ombudsman, I would first mention that in Rwanda we have an ombudsman, but not a tax ombudsman. This ombudsman is mainly in charge of three things. One is fighting against corruption. Number two is fighting against injustice. Number three is to look at the conduct of high officials. And among or within the context of fighting against injustice, our ombudsman has the power to review the judgments in general. But when you talk of judgments in general, this may include the judgment relating to tax-related cases. However, as I also said, this is a general mandate, which is not specifically tailored to the issues of the tax. So how are the tax procedures, so the tax disputes, how are they resolved in Rwanda? We have any tax dispute, it starts with an administrative appeal. That is to say, the law clearly says if there is a taxpayer who is not happy with a decision taken by the Rwanda Revenue Authority, that taxpayer must, first of all, make an administrative appeal asking the Revenue Authority to revise the decision taken. In some cases, the tax administration, they do revisions. In some other cases, they don't do revisions. And the law says if a taxpayer is not happy with the outcome of the administrative appeal, the taxpayer can go in court. And in that one, the competent courts are the commercial courts, which are defined from the structure in some other EAC jurisdiction where you have specific tax tribunals. Another element to mention with regard to the resolution of the tax disputes procedures is about the possibility of an amicable settlement. The law says, and in practice is done, that a taxpayer can ask the tax administration to resolve the disputes through the amicable settlement procedures. And this request can be done anytime. If we say anytime, it means as long as there is no final court decision, the request can be made. And if it is made, there is a committee, of course, dominated by the Rwanda Revenue Authority, which is in charge of engaging in amicable settlement procedures with the taxpayers. So now, regarding the exact topic of today, the question is there a need for a tax ombudsman office? So to this question, for me, the answer can be yes, as the answer can be no. One, the answer can be yes if this tax ombudsman can do some changes to the existing system. But the answer will be no if this office will not do any change, if it will just come and function in the usual bureaucracy. So there will be no need of having an institution which comes to add to an existing institutions which are not doing anything. And the main concern for me, I really enjoyed reading the paper by Solomon, and in his conclusion, he has a good hope that the tax ombudsman can do some good things compared to existing institutions. IGG, Inspector General of Government, Office of the Auditor General, Tax Appeals Tribunals, etc. I also enjoy the statement by George Kashin, who said that if the tax ombudsman can properly function, and I think that is where the problem is. Because today, if I opine from the perspective of Rwanda, we have the courts which have a mandate to decide and provide a decision in the case there is a misunderstanding between a taxpayer and the tax administration. So in other words, for me, the problem is not an absence of institutions. Probably the problem can be the functioning of the existing institutions. If existing institutions are not efficient and if they're not effective, of course, it's problematic. But the challenge is, which hope can one have that the tax ombudsman will be efficient and will be effective? Just to conclude on a joke, you know, some African parents, they lack in general having several children, and sometimes when you ask an African parent, why do you have a desire to have more children when you have 5 or 6? And the answer is the children are very good for me. So I will give birth to another child who may be different from the children that I have. So which means African parents, they tend to have a trust in unborn children than in born children. So the people here with institutions, 7 institutions, by the way, but the complaint is those institutions are not working properly. But there is a hope that another institution called Tax Ombudsman, which is not yet instituted, may come and correct the deficiencies of the existing institutions. So in a brief, my point is the issue is not having a taxman or not. The main issue is to have an institution which is efficiently and effectively functioning. John, I think I may stop by here as of now. Maybe I'll be back. Thank you so much.
Thank you very much, Dr. P. I like the fact, the point about the efficacy of the existing institutions. I think to one extent, I agree on that. I don't know whether just assuming that the existing institutions we have, for example, the Revenue Authority, the General Ombudsman, are efficient, whether we shall have a tax system which is responsive to taxpayer needs and which is morale boosting to the taxpayers. I don't know that that is possible, but thank you very much, Dr. P, for those points and sharing the Rwandan experience. And yeah, I'm seeing quite a number of questions in the chat and in the Q&A, and I think Solomon has done a good job trying to answer some of them. I hope all of us have access to our Q&A. Solomon has really tried to answer them. I don't think it's necessary for me to read them out. You can just open the Q&A and look at the questions plus the answers. I've also seen a few questions in the chat. Maybe I could read them and so that they are addressed, and then we can get into the second phase about the issue of a regional tax ombudsman. Let me just start with Cephas. I think Cephas noted something here. Don't you think it's ironical that the tax ombudsman proposal should be in the URA corporate plan and appears nowhere else? I think he was reacting to Solomon's presentation. Probably Solomon could come in and answer that Let me just look out for the other one from, I think this is from Simon. From Solomon's presentation, the number of issues that may not be satisfactorily addressed appears to be high. What would be the proportionate number of staff working with the Ombudsman? I think that's also something that Solomon can take up. I don't know that there are any other questions before I get back to the panelists from what has been discussed so far. I think there's something from Mark Mutumba here. Are there any scenarios or stats to indicate the percentage change in the DRM efforts in those countries? I think it's in regards to the creation of a tax ombudsman. And Brondel, I think, is appreciating the presentation from Solomon. So I don't know that there are any, I can see a hand. Let me just allow our audience to speak, and then I can get back to you, the panelists. Please feel free to share your experiences. If you have any questions, you can type them in the chat, or you could as well raise your hand, give you a minute or two to speak. I think Belmo here says, I share Dr. P's opinion on the need to strengthen the efficient functioning of the existing institutions instead of multiplying. I think there's also a question about the ombudsman being toothless. There's a comment, I think, in that area. And then also what the use would be of creating an ombudsman, and yet it does not make binding recommendations. I don't know. I think our panelists can have answers to some of these questions, especially the one on binding. Perhaps Solomon, as you come in, you could answer to it. And also, I could also, as I think Dorothy will also talk about it. But let me start with Solomon. You could answer some of the questions that have been raised. And then also, Solomon, as you answer them, I also want you to talk about the issue of having an ombudsman at a regional level. We are moving into regional integration, first of all at ESC level, but we're all aware that there is the Continental Free Trade Area, which is now already in operation. And it, of course, it means that we have to trade with each other at a continental level. So I don't know how possible this is, a tax ombudsman. I know whenever there is cross-border trade, there are issues to do with, there are so many complaints. I'm sure they will multiply by the day. And when it comes to taxes, and of course, I think we are already seeing it with the customs there in ESC. So I don't know whether we could, this is something that is visible for now, whether we have to first do some groundwork before considering it happening. Yes, please, let me start with you, Solomon, once again.
Yeah, thank you. Thank you very much, John. I think I'll start with Sepas's comment about the fact that the Ombudsman is mentioned in the corporate plan of the Uganda Revenue Authority 2020, the 2022 corporate plan. It is interesting that it's mentioned there, and yet definitely not going to be implemented. There is no sign or any movement in that direction. It's also mentioned in the domestic revenue mobilization strategy, but is also not being implemented, despite the fact that many other aspects of the strategy and of the plan are being implemented. And for me, that just highlights an element of lack of good faith in the operations, and the fact that the possible perception is that it is seen as a sort of hindrance to revenue mobilization, and which I think is a misperception, because I think they misunderstand it that way, because they at the end of the day, when you're in a revenue authority, you are being assessed on revenue collected, and when those targets are coming down heavy, you may not care so much as to whether the revenue is being collected legally anymore, or properly, and in a manner that doesn't really disrupt businesses or even operations of most people. So that it comes down to that, and I think if you asked, I mean, if it was an honest conversation, I think they would probably argue that it is more of a hindrance to revenue mobilization than a support the function. But that's just a skewed way of looking at things, which is understood and should be expected. The next question is on the number of people who should ideally work in the Ombudsman office. I think that might also need its own detailed research before that can be fully determined. If you ask the Revenue Authority right now, there are about 4,000 staff, just over 4,000 staff at the Uganda Revenue Authority, and they will tell you that they are understaffed. I'm not sure if there's any office that would tell you it is adequately staffed. If I was to hypothesize that the ideal, I say, would be starting with about 50 people, because that would be what would deal with the many issues as has been pointed out. And that may not be necessarily, that may be a little too high, I do not know. That would be something to be looked at empirically and understood. But from what I've seen, there are quite a number of issues, as is pointed out, and indeed, you would need a good number of staff, and then the number of staff could probably keep changing along the way. I did try to answer some of the questions in the Q&A, and one of the questions was about the toothlessness and the utility in having an ombudsman that does not offer binding recommendations. And the reason for that is because if the ombudsman, there are jurisdictions where the ombudsman offers binding recommendations. That's, for example, in the United States. But I would argue that's a bit more sophisticated jurisdiction, and they have robust systems in place that can make sure everything is handled expeditiously. But my concern would be, if it was offering binding recommendations, then you risk getting mired into issues of administrative law. You're applying for a compelling order, a certiorari, going into that direction. Yet what you're looking at is a process which can be accessed by the ordinary taxpayer, because the main challenge that you face is that the taxpayer comes to the Revenue Authority, and at the service desk, I worked at the service desk at the Revenue Authority. I worked at the service desk for 2 years. Then I worked at the compliance office for 1 year. Then I worked in policy for 4 years. So you come to the service desk and you have your challenge. You want it to be addressed, and for a number of reasons, you can't even find out why maybe your particular issue is delaying. So this is someone who should intervene and find out for you on your behalf and pursue it, and make sure if there is no valid reason for it to delay, it is expedited. And if there is a reason for the delay, it is communicated to you very quickly so that you can cure it. It's more of about a sort of soft hand in dealing with these issues. I know that because the Revenue Authority has excessive power, so there is a desire to create a full countervailing force to equal that power. My concern with that would be, then you just get caught up in two elephants fighting and the grass suffering. I would think those recommendations which are not binding are a better option, also to limit abuse of the process, so that if it is truly something that is just meant to abuse the process, then it won't be successful. But what should also be noted is that they as conceived in my paper, the tax ombudsman would not be toothless per se. They would have the power of publicity. That is, publicizing even the specific case that is not being acted upon, or even recommending it to the ministry for further action, or recommending it to Parliament for further action. And bringing these things out, I found when I worked in the Revenue Authority that if there are any of my former colleagues, they may forgive me for the analogies I keep drawing. I've referred to them as terrorists. Now I'm going to refer to them as cockroaches. That much like cockroaches, we thrived in darkness, in doing things secretly and dealing with people without the public knowing about it. So if these things are brought to light, I believe some action can be taken, and I know that when a few things were brought to light, they would actually be dealt with expeditiously. In the few instances that things were brought to light, then whether there is any utility in adding another institution to the very many other existing institutions, I would argue yes. Why? Because as I tried to point out in my presentation, perhaps not perfectly, and as I pointed out in my paper, that those other institutions, their mandate is limited already. They have inherent institutional limitations that prevent them from fulfilling the function that would be fulfilled by the tax ombudsman. The tax ombudsman is meant to do something that currently the tax appeals tribunal cannot do, that the auditor general simply cannot do. If my refund is delaying, or if I'm being denied VAT registration yet I qualify, rushing to the auditor general may not give me a solution. It may not be a matter that can be taken to TAT easily if there is even no tax decision to implement. So these are things which it is a space that is currently unoccupied. They are not taking on any other existing institution's mandate. This is a sort of desert area where something needs to be put in place to deal with it. And the question of the regional ombudsman, yes, I would think that there is definitely going to be a need for the regional ombudsman, because among the cases in writing my paper, I had to review quite a number of previous decisions to find the ones that were relevant. So I reviewed quite a number of them over a few months. And I found that there are scenarios that are coming up where the Tax Appeals Tribunal or the courts of Uganda are interpreting the East African Community Customs Management Act in one way, while the ones in Kenya are interpreting it differently. And even when Kenyan precedents are cited, the particular interpretation is not being adopted. So definitely you're seeing some issues arising there, and it might be helpful to have an overarching body that deals with the issues, because the processes specifically for customs are supposed to mirror each other ideally. So one would imagine definitely then you need a regional body that would deal with such issues as they arise. And maybe the last one is the question on, are there scenarios or statistics on the change in domestic revenue mobilization efforts? There are some studies. This is after the Ombudsman has been introduced. And there are some studies that have been done that they are not on the revenue mobilization that I haven't seen, and maybe that's something that could be looked into for further research. But there are some studies that show at least taxpayer perception. The taxpayer perception has greatly improved of how the tax authority, the relationship with the tax authority is perceived after the Ombudsman has been created. I thank you. Over to you, John.
Thank you very much, Solomon, for those elaborate answers. Just quickly, because we are running short of time, I think, Dorothy, you wanted to make a reply to, I think there was a question raised on the implications on domestic resources, domestic revenues. Dorothy, you wanted to answer that live, I think.
Yes, but I was typing somehow. So since I have an opportunity to say it live, with regard to that question, my answer will be that the state funds cannot be affected in any way, because to start with, the procedure usually does not take, for a case of Tanzania, for instance, it does not take more than 30 days to be determined, as in the matter has to be determined finally and conclusively within 30 days from the date that the matter was taken to the Ombudsman. And the great thing about this Ombudsman for the case of Tanzania, for instance, you cannot go to the Ombudsman if you do not have evidence. It's one of the requirements that before you go to file for a complaint, which is usually filed orally or in writing, you have to have evidence that there is a certain case that is going on, and you have to have proof that you've gone to the authority to try to resolve it, and there is failure. So I think this is a good strategy which tries to minimize the number of cases that goes to the Ombudsman, because you have to be sure that, first of all, you have gone through the local remedy at the authority, that is to say the TRA for the case of Tanzania, and that you've failed to get what you needed to get, or the time has taken more than 30 days. or they have not replied, or you're not satisfied. So this is to say that the first stage into making sure that you get the remedy that you need as a taxpayer is to go to the authority to start with. And once you're not satisfied, or in any cases or instances that I've clarified before, they're the case to you, that is when you get an avenue to use the ombudsman. So it's not so open to everybody to go to, and the fact that you have only 30 days to make sure that the case is determined finally and conclusively, and 15 days from the date of the decision to the Minister of Finance, who makes sure that now they go to the authority for determination and deliberations. It's almost 45 days, which is reasonable enough. And it's a good checks and balance mechanism. So in my opinion, in answering the question, I do not think that the state funds can be I don't know, misappropriated or something, or people may evade somehow to pay tax due to a large number of people who will be going to the avenue, because we'll be sure that those who go through the ombudsman really needs help and assistance, because it's something that is really out of control, and the time frame is very reasonable in my opinion. And as for the case in Tanzania, as this is what happens right now, so I think in answering that question, that is what I wanted to say.
Oh, thank you very much, Dorothy. Just before I go on to George, I just wanted to ask you to also share your thoughts on the regional tax ombudsman.
Okay, I'm not so far from what someone has shared, because it's evident that we need a regional tax ombudsman, considering the fact that we are moving into making like the East African community integration. So if we're to integrate the system, we cannot run away from making sure that we have the regional ombudsman that will be able to regulate the tax issues that are currently going on. For instance, a number of years back, I think Tanzania and Kenya had a number of cases regarding tax, particularly at the border and the Namanga border. And you would see that it was very chaotic to the governments of both sides and to the taxpayers, and much more to the end users of the services or goods from both countries, of which if this regional ombudsman was in place, it would be very easy, considering the fact that we hope that it will be an alternative dispute resolution, which will be very fast, confidential, and believing that matters taken there will be determined in a very short time, rather than the long dragging time that happened or took place to determine the cases that happened previously. So honestly, from my opinion, with the practical aspects of how we're operating as a region, it's very important to have an ombudsman at a regional level, so that the trade between the states and the intertrade among the East African nations can be done smoothly. And in case of any abuse or excessive use of powers by either of the authority, people know, taxpayers know where to go to, so that they get their issues sorted, and businesses and life continues smoothly without any challenges.
Oh, thank you, Dorothy. And the last one, I think, a question from Cephas saying that is the tax ombudsman provided for in the Constitution in TZ?
In Tanzania, to start with, we're having an ombudsman generally through the Permanent Commission of Inquiry in 1965, and that was in the Constitution, and it was very general, not specifically in relation to tax matters. And then that went on, and apparently in 2019, that's when the Finance Act amended the tax Administration Act by adding this tax ombudsman specifically. So what is provided in the Constitution is the ombudsman that is general, that was established in 1965. But this one specifically, it's not stated in the Constitution, but rather in the Finance Act, as it was established in 2019. So it's not in the Constitution specifically as a tax ombudsman.
Okay, thank you very much, Dorothy. Let me just allow me move on to George. In the interest of time, George, I just want you to answer to this question. I think it is raised by Austin Kitinya. He says one common problem with Kenya Revenue Authority, not sure about Uganda's, Kenya, Tanzania's, is the weaponization of the authority and extreme undue criminalization of tax-related issues. In Kenya, a company employing 4,000 people and remitting monthly tax of Kenya shillings 1 billion can be shut down by KRA for an alleged default of tax remittance of 50 million Kenya shillings. What would be the cure for this? Is the ombudsman a good cure for this, George? As you share, you could also share your thoughts on the idea of a regional tax ombudsman. Please go ahead.
Yeah, thank you, John, for that, and Austin for that very apt question. Actually, in Kenya and for KRA, it seems like the more compliant you are for tax, the more you are penalized. So the guys who are not paying tax are all over the place, but the few businesses that are paying tax are the ones that KRA is milking, dry completely, and even freezing the account. And I've shared a case which I did where the judge said, no. KRA, you want now to you want to eat the chicken plus the eggs. This is unacceptable, because this company was paying a lot of tax every month. If we looked at their ledger, they are remitting every month corporation tax, PAYE tax, but then KRA comes and shuts them. I don't think the ombudsman will deal with that. I think that is an issue that KRA needs to have a conversation. We need some shifting so that they treat their taxpayers well, and that could do with the changing their culture and changing really their strategy, so that they go towards compliance as opposed to auditing, assessing, and freezing accounts. On the regional issue, just last week I was approached by a client who was telling me they are manufacturers and they supply in many countries, and he was telling me country X is now charging us so much tax on this, yet we are producing here in Kenya. We have paid already this in Kenya. We don't need this. Was to rush to the East Africa Court of Justice, which could be helped if we had an ombudsman regionally. I can see my internet is unstable, but I hope you've understood me that my proposition would be that it will be important to have a regional ombudsman. Back to you, John.
Thank you very much, George, for those insights and answering. It's very interesting. I think we all in the East Africa community, we all share the view that revenue authorities operate like terrorists, as Solomon pointed out. But thank you very much, George. Still taking on some questions. I see there is a hand here. David, can you hear me? David, can you hear me? Can you just unmute David and go on? Oh, it seems okay, as we try to get to David, I see I've unmuted, but I think I don't know why he's not speaking. As we go on, probably let us hear from Dr. P. Dr. P, could you share your thoughts on the idea of a regional tax ombudsman? But also, I also wanted to hear from you about, I know you talked about the existing agencies being efficient. And in one way or another, I think you were saying that an ombudsman may not be necessary at the point, but ensuring that whatever agencies that we have in place are efficient. But I also want you to address the question of the maladministration, especially which comes in revenue authorities. I don't know whether that is the case in Rwanda. I don't know whether you have challenges. For example, the ones Solomon pointed out in his presentation on the part of taxpayers, especially when it comes to, for example, when it comes to refund, the times of processing refunds and, you know, some of those service-related challenges. I don't know how you would suggest that some of these are dealt with, especially if you feel that existing agencies should be more efficient. Can you hear me, Dr. P? Oh, it appears I think we lost Dr. P. I don't see him online again. But I can see David's hand. David, can you hear me?
Solomon?
Yes, David, please go ahead.
How are you?
I'm okay. How are you?
I'm good. I'm speaking from Tanzania, in a region called Dodoma.
Yes, please.
This is the head office of Tax Ombudsman Tanzania.
Yes, please. Go ahead.
Yes, we've been hearing the discussion and making follow-up on what you are trying to discuss. It's a good way of discussion that we have noted that you are very aware with the tax ombudsmans, in particular in East Africa. But in Tanzania now we are in an operational stage of which we expect it to kick off very soon after setting all procedures of recruitment and operationalization of the office. Our intention is to make sure that we take over taxpayers' complaints and deal with them, in particular, which relates to procedures, administrative and services. Currently, we are about 37 staff who are going to take charge at this start. And we'll be liaising with Tanzania Revenue Authority and taxpayers at large. But the compliance in general will be having some conditions in order you to lodge and get registered in our systems. You'll have to meet some conditions so that you can lodge your complaint. And sometimes we can say there will be existing some premature complaints. Premature meaning like you have not exhausted all scenarios from Tanzania Revenue Authority. So to us, we cannot accept it to register such a complaint unless you have completed all procedures with the Tanzania Revenue Authority. We are still looking also the instrument that established the tax ombudsman so that we can see how best we can make it operational so that it can give out a proper service intended by the government to taxpayers. In a real sense, the tax ombudsman is taken now as a compliance tool. A compliance tool in a meaning that solving or resolving the problem between the taxpayer and the revenue authority means creates a smooth collection of tax. And sometimes it can reach a condition where a taxpayer maybe has been complaining from maybe procedures that made him not to pay tax, so that he can clearly pay tax. So it's like a compliance tool, kind of.
Thank you. Thank you.
We are in Dodoma and making sure that soon we'll be starting operation. But our office is now live. Staff are already recruited. Resources are already mobilized. Now we are just waiting a kickoff so that we can go to the public, doing some sensitization, education, telling people about this platform, how should they submit their complaints, how long will it take to be resolved, and so on. Otherwise, when you have such a forum, please let us know. Thank you.
Thank you. Thank you very much, David, for sharing that experience. You talked about sensitization, and I remember Dorothy also highlighted it, the need for sensitization, because the tax ombudsman is still a new office, and the taxpayers need to know how it operates and how they can make the best out of it. So, and you also talked about the issue of the tax ombudsman being, the office being a tax compliance tool. And yeah, I think we shall be looking forward to see how that one works out. I think Solomon pointed out that a tax ombudsman should help in revenue mobilization, and I think those two correlate. So we shall be looking forward to see how that works out. Thank you very much, David, for sharing. I saw there was also a question as we close from Adisa. He says to the panel, any comment on the VAT harmonization in ESC, as well as portability of pension benefits? I don't know whether that really relates to what we are discussing today, but I'll give an opportunity to the panelists as we conclude to make comment on that. I also saw a comment from Lanmo. He said that harmonization should come first before we can have tax harmonization. In that case, I think should come first before we can have a tax ombudsman at a regional level. And I think I agree with that, because for now we only have the customs, which is harmonized. We need to also have a uniform tax system across the region in order for it to make sense. But I think I don't know what the rest think. I wanted also to find out from the panelists. Probably you can tell us as we conclude, where do we start from if we are to have a tax ombudsman in the current state we are in? As we close, let me call on. I don't know whether we have Dr. P back. Seems Dr. P is not in, but let me start with George. George, as you make your parting shots, can you just react to the, I don't know whether you have any comment to what Adisa, you have any comment on VAT harmonization in ESC, as well as portability of pension benefits, and also give us your closing remarks.
I didn't understand that much, but I would say that for we can have it gradual. We can have somebody at the regional level who is not a fully fledged office that helps, because a lot of customs and trade issues we evolve and harmonize everything, then will be good. Otherwise, I just want to say thank you to everybody, the society, as well as the panelists and John for facilitating this, as well as the attendees for attending. Thank you.
Thank you very much, George, as well, for joining in. Let me now move on to Dorothy. Dorothy, as you give us your parting shots, I see a comment from Trifin. At what point does it determine? Let me just read it through, Dorothy, as you come in. In Tanzania, the regulations provide that the tax ombudsman shall exercise his functions judiciously and independently without interference from any government officer, institution, or body. But in the end, this ombudsman prepares findings and recommendations and submits the same to the minister, who gives out directives on what should be done. Bearing in mind that the regulations provide that the Ombudsman determines complaints? At what point does the Ombudsman determine complaints if he only makes recommendations to the minister? And to what extent does this kind of a procedure guarantee the independence of the tax ombudsman if in the end, the minister may ignore such recommendations? Secondly, the legislations do not address on the issue of appeal in case the complainant is aggrieved by the directives of the minister. What is the remedy to this? Dorothy, as you come in, could you speak to that question raised by Tryphon?
Okay. Oh, okay. I was trying to look at the question. It is true that the Ombudsman is supposed to exercise the functions judiciously and independently without interference from any government officer. And that is why this body is very independent and it is created by the law. It's not under any influence, only that it has to report to the Minister of Finance because the Ombudsman has no direct command to the Revenue Authority. The Tanzania Revenue Authority is under the Minister of Finance. Therefore, even though the Ombudsman sit down and determine some of the cases, there is no way they have authority to the authority. And that's why in the challenges, I raised this as a challenge because there is no way it can have a direct effect or direct communication or direct contact to the authority, but rather it has to go to the minister and then from the minister to the authority, and then whatever needs to be done gets to be done. So this is an area where the law, it's what the law provides, and as it says, there is somehow, I can say, there could be a gap, but it's because of the structure of how it's established. But again, as we say, this is a new, very new structure that is still is yet to take place, is yet to start operations. Therefore, we believe once it starts, there will be policies and regulations and other things which will guide and govern these things to make sure that actually it is effective. So as we said, or as my previous panelists said, that it is, you can say somehow toothless, but not so toothless because it provides for an avenue to go through these complaints. This is a gap that is there, and we hope that once operations start, we'll then be sure if it works or it does not work and where is the gap. And I'm sure the country or the government will find a way of making sure that it is effective and it remains independent, because the Ombudsman being independent is one of the very, very core items in the law. The law provides for the same, and we believe that this will be able to be taken into effect. The regulations, yes, do not address on the issue of appealing the case of the complainants where they are aggrieved by the directives of the minister. And maybe the remedy could be to go to the tribunal or to the for the cases which may fall in both categories, because there are cases which could fall under both categories, as in they may be able to go to the TRAB maybe and try to those specific cases. That would be an avenue, but otherwise it's very correct. The law is, and the regulations do not address on the issue of appeal in case the complainant is aggrieved by the directives of the minister. As I said earlier, since we're still in the operational stage, once it starts operating, these loopholes, I'm so sure and I'm so certain that they'll be addressed, and there will be found a mechanism to make sure that they're able to be made in place to make sure that the Ombudsman Office has power and it operates to the capacity and according to what the law requires and wishes that it operates. So I believe once we start full operation and the law becomes fully in place, And with time, these gaps which we're hearing right now, obviously there will be regulations and there will be requirements by the Ombudsman that will make sure that they are covered and that there is no gap in the procedure in any way.
Okay, thank you very much, Dorothy. As you give your parting shots, I know you also agreed that we need a regional tax ombudsman, but where do we start in just 1 minute before we close?
Okay, I think we start with the harmonization of the tax issues, like it was stated earlier, because without the harmonization on the tax aspects, there is no way we can have a common ombudsman at regional level. So that's the very, very important thing, and it's very gradual. So maybe we could start with the areas or the tax areas which are possible to have harmony with. And in those specific areas, we could have an ombudsman generally. But what I can say is it's a great check and balance mechanism to the behavior and administrative conduct of officer of the authorities. Therefore, it's also a good way or a good mechanism of holding the authorities to its commitment of fair administration of tax. So if we are to want fair administration of tax at both country levels and regional levels, we cannot run away from having this ombudsman, because otherwise you could be seeing people officers misusing their powers and frustrating taxpayers, and then there'll be unnecessary delays in administrative matters. So in my opinion, it's very, very vital to have them in place, both at national levels and at regional levels. And for Tanzania specifically, the regulations which were put in place last year are a very positive step towards the improvement of the tax administration in our country. And in time, we'll know how effectively the Ombudsman performs in protecting the taxpayers' rights, which we believe that it will be in the positive, obviously, considering the fact that we're one among the very first countries in the East African region to have this Ombudsman in place. So I think it's a step to be applauded, because at least there is actually an action plan that is taking place towards achieving this improved tax administration in our country.
Thank you very much, Dorothy. Just your parting shots, then we go ahead.
It was a great session, and all the panelists have been very well invested in the knowledge of what they are saying. And we believe that with time, the whole region at least will have something in common with regards to this subject, in hoping that we'll have more discussions on the developments of the Ombudsman in other countries as they proceed. And hopefully also from our side in Tanzania, we'll have already started operating, and we can have more practical feedbacks from the Ombudsman.
Oh, thank you very much, Dorothy, for joining in. Dr. P, could you give us your parting shots, but also tell us where we can start from if we are to have a regional tax ombudsman?
John, can you hear me?
Yes, I can hear you, please.
Okay, yeah, good. Thank you. The question is very difficult to me, because to ask me where to start from, it's a bit tricky, because I'm saying this because when you look at several regional initiatives which have been initiated, just theoretically, we have good initiatives in EAC, but when it comes to putting into actions, almost all partner states of EAC are very reluctant to take the step. For this issue which concerns the tax, I think it will be more difficult in the consideration of the theory of tax sovereignty, because when you look at the ES partner states, we are somehow different socially and economically. And for the ES partner states to come across and reach an agreement for a point which concerns tax issues, it's very difficult. So taking a simple example, when you look at several discussions that have been held with regard to tax harmonization, but as of now, apart from the Customs Management Act, which is functioning, but other things are just in the papers, but not in practice. Look at those things of common market, free movement of goods, free movement of services, a free movement of persons. But in practice, what do we have that can be called common market? I'm a Rwandan, I'm a South African, but when I'm traveling to Tanzania, to Kenya, I need to go with my passport. When I reach immigration, they stamp it, they ask me, what are you coming to do here? So sometime we need to lie, I'm coming for a conference, or I'm coming to visit friends. But a good answer would be to say, I'm in East Africa now, I have a free movement. So why are you asking me what am I coming here to do? So where to start? We should start with the mindset. That's the key point. If the mindset is not changed, nothing can happen in the EAC as part of regional integration. In a brief, that is me. Most of the time when I'm opining about EAC regional integration, I say in the EAC we have a very good song. Integration, regional integration. But that is a song. It's just a song, nothing else. Partner states are characterized by nationalism. Each partner state is fighting for its own interests, with total disregard of the interests of other partner states. So we are still very far when we are talking of issues of regional integration. Is that my personal opinion? I'm not usually I'm not pessimist, but when it comes to EAC regional integration, I totally lose hope in the East. Yeah, thank you.
Thank you very much, Dr. P. You could just give us your parting shots because we are closing.
John, what did you say?
You could just give us your parting shots as well, because we are closing.
Oh, good. Yeah. So this is my last opportunity. So it was a pleasure for me to hear the discussion that has been held here. It was very enriched, and I have taken some facts, and have been able to understand what is happening in the other jurisdictions, which seems to be different from what is taking place in Rwanda. Because when I heard what is happening in Uganda and Kenya, it seemed there are misunderstandings and conflicts between taxpayers and tax administrations. So in Rwanda, since I think in 2014, there has been a program of tax education where taxpayers are being educated on becoming responsible taxpayers, because sometimes we are talking from the side of taxpayers, but also we need to be opining from the side of tax administrations. We have some jurisdictions like Finland where paying a tax is taken as a pleasure. Someone takes a pride of having paid tax, but we Africans, we don't like paying tax. For some reasons, I understand there may be some reasons behind, but if there can be proper tax education programs to educate people to become responsible taxpayers, but also that program to be successful, it must be in parallel with accounting the tax administrations, because someone cannot pay tax which will be misused. It doesn't make sense. So we need to work on both sides. But as I said earlier, I think the institutions we have, they're not perfect. If they can be strengthened, they can do good jobs. And I don't find it necessary to make a multiplication of institutions. But in general, the discussion is very nice, and I have been enjoying it. Thank you so much, John, and the participants.
Thank you very much, Dr. P, for joining us and sharing your thoughts. You've differed from other panelists, but thank you very much as well. Let me just go on to Solomon. Let me conclude with Solomon. Solomon, as you give your parting shots, you could also tell us where we can start from as if we are to have a tax ombudsman, a regional one. Yes, please.
Yeah, maybe my parting shots would just be that the Chief Justice Marshall in the US pointed out that the power to tax involves the power to destroy. And that's a power that should be wielded cautiously, and if not to overplay the analogy, but if that power is put in the hands of those who may misuse it, it might be the equivalent of putting a nuclear bomb in the hands of terrorists. I worked in the Revenue Authority for 7 years. I saw firsthand what it was capable of. And it's a power that needs to be mitigated. It's a power that needs to be exercised without a doubt, and exercised fully and sometimes even harshly. But at the same time, it's a power that needs to be mitigated. At the moment, the existing institutions are clearly inadequate by their existing mandates and by their internal institutional incentives and constraints. It is in that sense that I see a tax ombudsman as absolutely necessary, at least in Uganda at the moment. And without that, I think, I mean, even for the authority itself, much as pointed out, I think it was Cephas who noted it's in the corporate plan, but it's not doing it. There's clearly no plan of implementing it, because again, it's that fear that having a force that mitigates against your excesses may in some way limit you in fulfilling your mandate of revenue mobilization. And so that's why I think they become hesitant to move in that direction, or to support any moves in that direction. But at the end of the day, a tax ombudsman would support revenue mobilization. There is a strong, it's dubbed an integrated drive at Uganda Revenue Authority right now. But for those of us who are on the outside looking in, we see that as flogging a dead horse. Unless you give a solution to the actual problem, which is that you have a systemic issue where the alternatives available to a taxpayer when they are facing a challenge when dealing with the Revenue Authority make corruption a very tempting thing to engage in. It is set up in such a way that the force that is being brought to bear will lead the taxpayer to be tempted to engage in corruption of necessity. So unless an alternative is actually created, a legitimate, viable alternative in the form of an ombudsman, I don't see that integrated drivers heading anywhere realistically. So I think there is a need to embrace this approach from the perspective of revenue mobilization, even from the perspective of the Revenue Authority. I think that is how it ended up in the corporate plan. As regards a regional ombudsman, yes, I think there need to be some bit of more harmonization, perhaps, heading towards that. I think on the side of the customs law is where it would primarily begin, practically, because that's where there is clear harmonization. And also because the customs processes are almost all supposed to mirror each other by law. I mean, the customs laws match each other, and the processes are supposed to match each other. So it's very easy to have a regional body that monitors the standards set, the service level agreements that have been set by the Revenue Authority, and ensure that those are being met. I thank you.
Oh, thank you very much, Solomon, and to all our dear panelists. Thank you for joining us, everyone. Thank you. Whoever commented, whoever asked any questions, thank you very much for sparing time to join us today and discuss about the relevance of a tax ombudsman across the East Africa region. Your comments are noted, and this is the first in a series of webinars, tax webinars on a a tax ombudsman. We are going to be coming up with many more, and please, whenever an advert comes in, please endeavor to join in. Once again, thank you very much, and I think this is it for today. And let me wish everyone a good evening.